defense policy. Our first speaker is Federico Casolari, Professor of EU Law at the University of Bologna. Federico's contribution is on the EU member states' interactions with security implications and the implementation of the EU strategic autonomy doctrine. Our second speaker is Bram Vroege. Bram is a PhD candidate at the University of Utrecht and a senior lawyer at the Dutch Authority for Consumers and Markets. His presentation explores the European Defence Fund. Our final speaker is Stephan Marquardt. Stephan is a deputy head of the legal department of the European External Action Service and the head of the Division for EU External Relations Law and Public International Law. His presentation concerns the legal nature of civilian CSDP missions. Federico, the floor is yours.
Thanks a lot, Eva. Let me also thank Ramses for the kind invitation. It's always a pleasure to be here, to participate to CLEER activities. Actually, my contribution will deal with an issue of competence, the allocation of competences actually between the member states and the European Union when it comes to security issues, in particular issues related to the protection of national and supranational security. So the presentation, I don't know how to use it, sorry. Technology sometimes. Okay. Perfect. So I have just, okay, thanks a lot. So this is the outline of my intervention. I will say very brief words on the security nexus we have in the strategic autonomy doctrine of the European Union. Much more has been already said this morning, so I don't need to spend some extra time in clarifying this element. But in any case, I will introduce some considerations. Then I will try to make reference to the state of the art when it comes to the interaction between national security and EU law, which is relevant in order to understand what kind of activities, what kind of instruments and actions the European Union may put in place in order to fulfill the objectives of the strategic autonomy doctrine. And I will try to consider 3 case studies which are related to 3 different initiatives put in place within this doctrine, the strategic autonomy doctrine, in order to highlight some legal issues and some problems that the institutions are facing in trying to solve the question related to the allocation of competence with member states. And we'll see that there is a, let's say, a common element connecting all these cases. So very few words to say what is crystal clear to me, the fact that the protection of supranational interests and national interests is part of a strategic autonomy doctrine of the European Union, I would say is the core of these doctrines. So the EU should elaborate instruments and capacities in order to become autonomous, in order to protect its interests and the interests of member states. And this is also relevant when it comes to security issues. So you can see here a figure coming from a document elaborated by the European Parliament, where you have all the major strands and elements of a strategic autonomy doctrine of the European Union on the one side, on the other side, the Maslow pyramid, and you can see how security issues are relevant in this context. That's why, to me, it's important to try at least to shed some light on the allocation of competences between the member states of the European Union in this context. So the starting point when it comes to the protection of national security is, to me, Article 4.2 of the Treaty on the European Union, saying that the Union has to respect some essential functions of member states, including the maintenance of law and order and safeguarding of national security. And in particular, national security remains the sole responsibility of each member state. This is the English version of the treaty. In the Italian version, it is said that national security is an exclusive competence of member states, is a competenza esclusiva. So it's different, the wording, but it's absolutely clear that it's an exclusive competence of member states. So we could conclude, I could conclude my talk by saying that national security remains with member states, and that's it. So the European Union cannot intervene, cannot elaborate initiatives and tools in order to implement the strategic autonomy doctrine. Of course, we have a practice. Of course, we have other principles enshrined in the very same article of the Treaty of the European Union, in particular, the principle of sincere cooperation, which is mentioned in paragraph 3 of Article 4. And thanks to the interaction between the protection of prerogatives of member states mentioned in paragraph 2 and the principle of sincere cooperation, which is mentioned in paragraph 3 of the very same article, the case law of the European Court of Justice had the opportunity to elaborate what has been called, in a very recent case by the Advocate General I'm sorry for the pronunciation. Is it correct? Okay. What has been called the framing of powers doctrine or theory. So the idea that even in contexts where member states enjoy an exclusive competence, member states have to take into consideration the consequences that the exercise of those competences may have on EU law, but also on the other member states. So they have to have due regard to the consequences in terms of effectiveness and implementation of EU law. So it's an exclusive competence, but at the same time, EU law may play a role trying to limit the discretionary power of member states. We have different illustrations of this theory in different domains, in EU citizenship law, in the context of the organization of the judiciary systems of member states, for instance, but we have also cases related to security issues and to national security in particular. And in this light, you have a reference to a judgment given by the Court of Justice in an infringement procedure against Poland, Hungary, and the Czech Republic. It's a case related to the implementation of relocation decisions that were adopted in order to try to face the migration crisis, the refugee crisis. As you know, different states decided not to implement in the proper way those decisions, and there was an infringement procedure against some of them. And in this procedure, the member states tried to make the argument that the decision not to implement EU law was adopted in the light of the need to protect national security interests. So they tried to invoke inter alia Article 4.2. Well, here you have the answer given by the Court of Justice in this case. The Court of Justice says that this clause, which is included in Article 4.2, cannot be interpreted by the member states as a sort of general reservation to EU law, as a sort of carte blanche. They have to take into consideration the consequences of their behaviors when it comes to the effectiveness of EU law. So this is, let's say, the general framework that we could use in order to understand how, let's say, member states may try to limit the action that the EU could decide to elaborate in the context of the strategic autonomy doctrine. And I would like now, with this in mind, to mention three cases, three initiatives that have been put in place recently by the EU institutions, where we have different let's say, balances between the need to protect the national interests, the national prerogatives, according to Article 4, Paragraph 2 TU, on the one hand, and on the other hand, the need to make sure that the member states' action will not undermine EU law and the supranational objectives. So the need to take into consideration the loyalty duties of member states towards EU law. The first case is a regulation. I think it's very well known in this room. It's a regulation that was adopted in 2019 for introducing a screening mechanism for foreign direct investments into the Union. Very briefly, this regulation introduces a mechanism making possible for member states to notify that a foreign direct investment that should be established in another EU country could represent a threat to national security and public order. And according to this, let's say, alert that could be notified by member states, a coordination mechanism shall be put in place involving the European Commission and, of course, the hosting EU country. Well, in this regulation, we have the two opposite elements I tried to describe before, put together in a minimalist attitude. On the one hand, recital 7, the need to make sure that member states will be the sole responsible when it comes to national security, as provided in Article 4.2, and the need to make sure that the host state, so the state of the place of investment, will be the sole responsible of the last decision on, let's say, the operation that should be elaborated in this respect. On the other hand, recital 17, the need to take into consideration the principle of sincere cooperation, Article 4, Paragraph 3. So member states have to elaborate a coordination mechanism, a coordination instrument, and the member states deciding on the investment has to, let's say, give grounds and reasons with regard to the objections or the arguments made by the other countries. So there is a duty to, let's say, elaborate a cooperation coordination system. So we could say that a first attempt to elaborate a balance between these two different, let's say, elements is to create a cooperative system according to which member states have to inform themselves and try to share doubts, problems, and worries about national security issues. The second case I would like to mention is different when it comes to the balance between these two different tensions. It's a proposal for a regulation. It's a very recent proposal that has been adopted by the Commission in order to strengthen the resilience when it comes to semiconductor elements, due to the shortage of these elements at EU level. It is, let's say, it has been elaborated under the context of a so-called digital sovereignty, which is in turn part of a strategic autonomy doctrine of the European Union. And what it is interesting in this case is the circumstance that the idea is to, let's say, introduce harmonized rules at EU level in order to have a common resilient platform for facing crisis related to the shortage of semiconductors. And this should be done by relying on Article 114 TFU, so the harmonizing legal basis we have when it comes to the internal market, meaning that it should become, let's say, an obligation for member states and the institutions to create a cooperative platform with harmonized rules in order to protect national interests and supranational interests. And this should be done in order to prevent unilateral actions of member states that could jeopardize the fulfillment of EU objectives, in particular when it comes to the protection of EU internal market. Again, sincere cooperation. One of the major duties in member states have under the loyalty clause is to refrain themselves from acting if the behavior they would like to put in place may jeopardize the fulfillment of EU objectives. So here the idea is that in order to make sure that the internal market will be preserved, and taking into consideration the need to protect national interests, but also supranational interests, member states must refrain themselves from acting unilaterally. They must act according to the harmonized rules that will be put in place thanks to this regulation. So it's different, the balance. I would say this is a maximalist attitude of the role that the EU may play in this respect. But again, it is made taking into consideration, let's say, also the position of single member states. So it represents to me, let's say, a fair balance between the interests of the state and the interests of the European Union, which is not probably the case when it comes to the last case I would like to mention, which represents to me an example of a strong maximalist attitude that could be put in place by the EU institutions within the context of the strategic autonomy doctrine. It's another proposal, I think very well known too. It's a proposal for a regulation introducing an anti-coercion mechanism in order to react to economic coercion put in place by third countries. According to this regulation, which is based on Article 207, so it is conceived as a common commercial policy instrument, so an exclusive competence of the EU, the EU institutions could react to economic coercion attitudes, behaviors of third countries, firstly by trying to negotiating and identifying let's say, friendly solution of a situation. But as a last resort mechanism, EU institutions could also adopt countermeasures related to the trade contractual relations with the third country concerned. Why this proposal could represent to me an example of a maximalist attitude of the EU role with regard to the protection of national and supranational security, because it seems that by relying on Article 207, the EU institutions could have the opportunity, in this case, to qualify the behavior of third countries as breaches or violations of international obligations, even when it comes to relations these countries have with the member states, alone. So I'm not speaking about violations of the contractual relations of the European Union with third countries. In this case, it's clear that the institutions could invoke the international responsibility if there is a breach, if there is a violation. When it comes to the protection of national interests of member states, when it comes to possible violation of obligations third countries have with regard to the relations with member states, well, maybe it's more debatable that the European Union may exercise an exclusive competence in deciding to adopt countermeasures. This is also taken into consideration another element of practice we have at disposal in the context of sanctions. It has been adopted, as you know, horizontal regime which is of sanctions, which is applicable to malicious events and cyber attacks. Well, it is interesting to note that in the recitals of these of the instruments introducing this regime in the Common Foreign Security Policy decision, there is a point where it is clearly stated that the sanctions the European Union may adopt, and the fact that the European Union may adopt those sanctions, is without prejudice to the competence member states have to identify the international responsibility at stake. So it seems that when it comes to the qualification of an event as a breach of international law, member states should still have a possibility to say a word. This proposal seems to limit such a possibility in the light of having a common and maybe stronger reaction. So to conclude, these were nothing but 3 examples of possible different balances between the need to make sure that the EU objectives will be fulfilled when it comes to the protection of supranational security in the context of a strategic autonomy doctrine. And on the other hand, we need to make sure that also member states' prerogatives are protected too. In all cases, a pivotal role is played by the principle of sincere cooperation, and we have seen that different solutions are possible. In particular, there are cases where it seems that the course of action that the European Union could put in place could be, let's say, understood in a stronger way in order to make sure that member states will comply with their loyalty duties towards the Union. This is, of course, perfectly consistent with the loyalty clause, but the loyalty clause, at least after the entry of the Lisbon Treaty, has been understood as a mutual loyalty clause. So it's true the member states have to show loyalty towards the Union, but it's also true that the Union should do the same towards the member states in fulfilling the EU objectives. That's why I think member states of the European Union should try to identify a more fair balance, taking into consideration the different positions. And of course, this is not an easy task. Thanks a lot.
Federico. Bram?
Thank you very much for your attendance, and thank you for having me here. Before I begin, because I'm also a public servant at the Dutch government, I would like to emphasize that I'm speaking here purely as an academic and that my views do not represent those of the Dutch government. That being said, today I'll be giving a contribution, if this works. It does. Let's see. Yeah. On the European Defence Fund, which is a relatively new instrument from the European Union introduced last year, through which it hopes to both enhance its industrial autonomy and boost the military capabilities of its member states. In this presentation, I'm first going to cover the policy context within which the European Defence Fund regulation was adopted. After that, I will explain how it functions and what it teaches us about the positioning of the EU as a defense actor. At its core, the European Defence Fund is a tool for driving defense industrial innovation. As is clear from the war in Ukraine, success in modern warfare is increasingly dictated by high-tech weaponry rather than mass manpower. But within the EU, defense research and development investments have been lagging behind compared to other major powers. In order to help drive such investments, the EDF provides a European budget to co-finance R&D activities. This, in turn, is meant to assure that Europe, the EU, can autonomously produce future cutting-edge military equipment. But driving defense innovation is not the only reason behind the EDF. Perhaps equally important is the EU's long-standing goal of deepening cross-border industrial integration. The EU defense industrial landscape is still highly fragmented along national lines. That is because even within the EU, national governments purchase their military equipment mainly according to geopolitical logics. In many European capitals, buying national is seen as the most secure choice. That is because reliance on foreign suppliers exposes a state to a risk of foreign interference, thereby limiting its freedom of action. As a result, the natural reflex of states is to do what they can to remain autonomous from a military-industrial perspective. Yet simultaneously, industrial realities prevent all but the largest countries, such as China and the United States, from achieving effective industrial independence. So for most states, the real question is not if they should engage in military-industrial cooperation, but rather with whom and how. EU member states answer these questions in different ways. In case national production is no longer feasible from a budgetary perspective, member states may band together to develop a joint European platform. A successful example of this is, for instance, the Eurofighter Tycoon, which is a jet plane that was developed by a number of different European countries together. But more often than not, member states will forego European cooperation and instead purchase their equipment across the Atlantic. As such, the defense procurement landscape in the EU is characterized by a combination of national protectionism and reliance on American production. From the EU's perspective, this situation is undesirable. A more integrated and independent European defense industrial base is considered an important precondition for developing a more autonomous EU defense policy. Accordingly, the EU has, since the mid-2000s, deployed a number of initiatives intended to drive industrial integration. Of particular note is the 2009 Defense Procurement Directive, which requires member states to follow an EU tender procedure when purchasing new equipment. But this directive, which is based on the logic of the internal market, has proven unsuccessful in practice. Contrary to the Commission's assumptions, member states continue to base their purchasing decisions on their own geopolitical assessments. These are hard for the European Commission to challenge as long as there is no integrated and true EU defense policy. As such, the EU has for now decided to abandon its attempts to strictly enforce the directive, setting out instead to find other ways to bring about EU integration. Since the root cause of the Defense Procurement Directive is a failure of harmonization in defense policy, a logical next step would be for the EU to act through the CSDP, its own common security and defense policy. But constitutionally, the CSDP differs greatly from other areas of EU actions. It is not supranational like most fields of action from the EU, but rather it is intergovernmental, giving the member states, in particular individual member states, a lot of decisive influence on decision-making. This is mostly because decisions are taken by the European Council, which, as a rule, acts unanimously. On top of this, as was also explained by Mark van der Woude earlier this morning, there are certain limitations to the extent to which the CJEU can review decisions taken in the context of the CSDP. Furthermore, legislative acts are excluded, so the normal tools such as regulations and directives are not available to the EU in the CSDP. And on top of that, there are certain funding limitations. As a rule, the EU is precluded from funding operations with military or defense implications from its own budget. It is possible for the EU to create so-called extra budgetary instruments. The European Peace Facility is an example of this. But it means that for defense-specific operations, the EU's own budget cannot be autonomously used. But the EU's toolbox is of course wider than the CSDP alone. As is evidenced by the Defense Procurement Directive, it is possible to a certain extent to use other elements of EU action to reinforce or assist the achievement of CSDP goals. By designing the EDF in such a way that it focuses on the defense industry rather than on defense ministries, the European Commission has managed to create an instrument outside of CSDP structures, which may nevertheless be used to drive forward defense integration. So how does this work in practice? Well, this is an infographic which provides a basic overview of the setup of the EDF subsidy scheme. At the heart of the EDF lies an annual budget of just over €1 billion per year. For context, pre-Ukraine war, before member states started expanding their defense budgets, this made the EU roughly the third largest defense R&D investor within Europe. So it's quite significant in terms of budget. Roughly a third of this budget is reserved for research activities, which are aimed, for instance, at discovering new and disruptive technologies. Such research activities can benefit up to 100% from EU funding through the EDF. The remaining 2/3 is allotted to development activities, aka activities that are meant to bring research into action, such as prototyping. The closer a development activity is to final production, the less money can be allotted from the EU's budget. And the reason for choosing such a structure is mainly because it is particularly hard to get EU member states to engage in more fundamental research. So it's particularly this sort of research that the EU really wishes to stimulate. And finally, once a product has been completely developed and is ready for action, it of course has to be acquired, aka procured by the member states. The EDF does not provide any budget for this because of course there is no EU army. And as mentioned, direct military spending from the EU budget is prohibited. Because one of the EDF's main aims is fostering inter-EU cooperation, its funding is only available for multinational projects. This is assured by requiring participation from legal entities that are established in at least 3 different member states. Participation from allied non-EU countries such as the UK and the US is also possible under certain conditions, but in principle it is excluded because the whole aim of the EDF is to ensure that the EU develops its own capabilities on its own soil. The material interaction between the EDF and the EU's defense goals is also apparent from the criteria that are used to determine how funding is awarded. While the EDF does include more economically oriented criteria, such as enhancing cost effectiveness, funding is awarded primarily on the basis of defense-oriented goals, such as a product's capacity to generate battlefield advantages. On top of this, the EDF explicitly requires R&D proposals to be consistent with the CSDP. Through this, the EDF regulation tries to ensure a unified approach to defense industrial policy across EU domains. This consistency requirement is essential because the fact that the EDF falls outside of the CSDP does create certain coordination challenges. Under the CSDP, there already was a specific entity which is responsible for developing an EU defense industrial policy, namely the European Defence Agency. But under the EDF, it is the Commission which ultimately controls how the EDF budget will be spent. How this sort of dual structure will work out in practice remains to be seen, but in any case, it creates challenges and potential for friction. So what can we expect from the EDF? Will it succeed in driving innovation and bringing about a truly unified European defense industry? Well, responses from member states and from industry alike have been generally positive, but a lot of challenges still remain. The EDF's ultimate success will depend greatly on the extent to which member states harmonize their other policies in the context of the CSDP. This is because money alone is not enough to drive defense innovation. For significant and inclusive joint programs to come off the ground, member states must first decide from what Europe should be protected. In other words, what are the relevant threats and vulnerabilities that should be addressed? In the short term, there is now, of course, broad agreement that Russia constitutes the most significant threat to European security and that European armies should be equipped accordingly. On top of this, earlier today it was already mentioned that a strategic compass has been drawn up, which sets out the European Council's view on its geopolitical surroundings. However, a lot of issues still remain. It is essential for the EU's member states to look further and grapple with difficult questions, such as what position to take in relation to Taiwan and how interventionist the EU wishes to be in its own backyard. Next, member states must decide when and how to invest. How is development and procurement to be organized? If one member state intends to replace its fighter jets in 5 years, while another member state intends to do so in 15, this is of course going to make it very difficult to align R&D spending. Therefore, action should be taken to align procurement and budgetary cycles. Finally, member states must keep a consistent course on investment decisions and take action to maintain the necessary domestic, political, military, and societal support. Weapons development can take decades, and the threat of one or more member states dropping out of a project due to a political changing of the guard may make companies reticent to commit. Developing new generations of weapons is a marathon and not a sprint. For the EDF to truly be able to make an impact in the long term, it is therefore essential to ensure robust and structural cooperation in defense strategy and procurement. That brings me to the final part of my contribution. What are the broader implications of the EDF for the EU and its role in defense? In my view, they are threefold. The first is the implication that the EDF has for the distribution of powers within the EU. Though the Council still reigns supreme within the CSDP, the EDF marks the definitive rise of the European Commission as a credible actor in security and defense. It is no longer trying to indirectly influence member states' procurement decisions, but is now equipped to actively steer those decisions through financial incentives. It will be interesting to see how this rebalancing of influence within the EU may affect the development of EU defense policy more broadly. The second is the material influence that the EDF has on EU defense policy. The latest communications from the Commission on Defense indicate that joint EU national financing for multinational projects may be introduced more broadly. Already, a proposal for a 500 million short-term procurement fund has been announced, which is intended for jointly replenishing stocks of equipment that have been sent to Ukraine. Later this year, the EU also expects to announce a regulation eliminating value-added tax for defense equipment that is purchased via joint procurement. On top of this, the EDF itself is also expected to be expanded. Some of these proposals do beg the question how far the EU can go with such financing. After all, there are limitations to what it can do, in particular when it comes to financing operations with military implications. The short-term fund specifically seems to really be pushing the limits here. And I saw yesterday already that the Finnish government has announced certain concerns regarding the subsidiarity of the measure. Finally, the EDF has implications for the EU's identity as an international actor. From a normative perspective, the EDF marks a major shift for the EU. For decades, it has been a prominent soft power actor advocating for more restrictive arms export policies in order to mitigate the negative externalities of the international arms trade. Yet now, the EU is actively sponsoring the European defense industry to develop new weapons, which may also be sold on the global arms market. Will such made by EU weapons be traded and used responsibly? Or will their remains turn up in the ruins of houses and hospitals half the world over? Considering the track record of certain member states and the weak ethical safeguards included in the EDF regulation, this does not seem to be an exaggerated fear. Thank you for your attention.
Thank you. So let's move on to the next topic, legal nature of civilian CSDP missions. First of all, thank you very much to you, Ramses, and to the ASA Institute for inviting me. It's a pleasure to be here in The Hague. It brings back some nice memories, because a long time ago, I had the privilege of spending 3 months at the Peace Palace nearby, working as a German intern for the then registrar of the court. So, and since then, I've been back also many times on other occasions. Of course, I speak here on a personal capacity. I think we're under Chatham House rules anyway. The legal status of civilian CSDP missions that may seem at first sight a bit of an esoteric topic, but it's, I think, very much relevant in the general context of or the general topic of this seminar. Indeed, as I mentioned in my comment this morning already, I think both civilian and military CSDP missions and operations are one, I think, very prominent example of the EU's autonomy. CSDP missions have been in existence since long before the Treaty of Lisbon. I'll briefly touch upon that. And indeed now, for example, one significant element that I would just mention en passant, because it's about military operations. You may have seen that quite recently now through council decisions, the EEAS has built up a so-called military conduct and planning capability, called the MPCC, which for the first time, and that's quite significant, will also give the EU a capacity to conduct military operations and in a near future probably also even executive military operations without being obliged to have recourse, for example, to NATO assets under the Berlin Plus arrangements, which, and this until now, of course, was a certain limitation on the EU's autonomy, at least as far as military operations are concerned. Civilian missions, of course, are fully autonomous, even though then we have many instances where third states participate in EU civilian operations. For that purpose, the EU concludes so-called participation or framework participation agreements with third states. Civilian missions, as I said, existed before the Treaty of Lisbon already, but since the Treaty of Lisbon, indeed, they have, and hence the topic, they have given rise to quite a number of wide-ranging and complex legal issues. I think some of which Mark alluded to this morning already. So they raise indeed, just briefly to summarize, the question of the jurisdiction of the Court of Justice of the EU in the CFSP and CSDP. Since 2014, and that's also directly linked to this topic, the Council has decided, unlike military operations, to confer an express legal capacity on civilian missions. And indeed, if you look at the institutional actors that are involved in the setting up, in the running of CSDP missions, the Council, the Commission, the High Representative, the External Action Service, of course, that in itself also raises a number of difficult questions regarding the respective institutional links, in fact, between these institutions and the missions themselves, which is probably why also in the several cases we have before the Court of Justice, in fact, we find that the applicants have difficulties identifying the right defendant. Most of these cases have been brought against the mission, Eulex Kosovo being a prominent party, but then at the same time against the Council, against the Commission, against the External Action Service. And I'll come to that in more detail. And lastly, they also raise fundamental questions about the EU's non-contractual liability. I mean, the question being, can the action or the inaction of a mission give rise to the non-contractual liability of the EU? And we have one pending case there that will perhaps provide answers to that question. Let me very briefly go back in history. Pre-Lisbon, indeed, civilian missions exist since 2000, post Treaty of Amsterdam. They were set up at the time, in the context of the European, or based on the European Council conclusions of several European Council conclusions, whereby the EU had decided indeed to give itself this capacity to launch on an autonomous basis, to launch a so-called crisis management operation for the wider objective of maintaining peace and security, or rather, more often also post-crisis, to deal with post-crisis situations. The successive European Council conclusions define the main goals of civilian missions. The first missions we had were mostly police training missions. Then later on came the so-called rule of law missions, and we still have one of the biggest civilian mission, Eulex Kosovo, very much focused on the question of the rule of law. We have then developed a number of other training missions with different specific purposes. So all this existed already before Lisbon. Within the Council Secretariat, we created, under the impulse of Javier Solana, the first Secretary General, High Representative, we created the necessary structures for the development, planning, and conduct of CSDP missions. This has been, of course, then pursued after Lisbon as well. The Treaty of Lisbon operated a number of significant institutional changes into the EU's external relations architecture, as you know, starting notably with the creation of the function of High Representative of the Union for Security and Defense Policy, assisted by his or her own service, the European External Action Service. Before, as I just briefly alluded to, the whole CSDP was developed from within the Council Secretariat under the guidance of Javier Solana, but still it was done kind of in-house in the Council Secretariat. The presidency still also had a fundamental role in terms of taking the initiatives. Now this is very much a remit responsibility of the High Representative, supported by the External Action Service. The Treaty of Lisbon has created a whole new section in the treaty devoted to CSDP, in itself also a significant development, with two specific legal bases, Articles 42 and 43, that are the legal bases that the Council uses when deciding to establish a civilian or military mission. Before, as you may know, before Lisbon, there was no specific legal basis. Civilian or military missions were established on the basis of Article 14, now Article 28, operational actions of the EU outside the EU. So who are the institutional actors that are then currently involved in the setting up of a CSDP mission? Obviously, the Council remains the central decision-making body, but the HR has a significant role in the preparation of a CSDP mission. The Council, even though the Council in theory under the treaties could also take decisions on the basis of proposals from member states, that has only happened in PESCO until now, but that's because there's a specific legal basis that foresees a specific role for the member states. Other than that, I'm not aware of any example where the Council would have adopted a CFSP or CSDP decision on the proposal from a member state. So all the proposals indeed to set up a CSDP mission, including the whole preparation phase, the whole planning phase, that is done, that is based on a proposal from the High Representative to the Council, and of course the whole preparatory work is done by our crisis management structures within the EEAS. But the Council, of course, is the main decision-making body. The Political and Security Committee has a prominent role here. Of course, under Article 38, paragraph 3, the Council, as a matter of standing practice, delegates a number of decision-making powers to the Political and Security Committee. All the decisions that concern the strategic direction and political direction of these missions are done by the PSC. The Commission, where does the Commission come in? The Commission comes in the financing. Unlike indeed military operations, as was just mentioned, CSDP, civilian CSDP missions are financed, can be financed, unless the Council would decide otherwise, but they, as a matter of routine or standing practice, they are financed from the EU budget. So the Commission is responsible, of course, for the execution of the EU's budget, including the CFSP budget. And therefore, the Commission plays an important role, because it is the Commission that will then conclude a so-called financing agreement under the financial regulation with the respective mission. It's for that purpose mainly that the missions have been given legal capacity in 2014. The Commission will conclude a financing agreement with the mission, so-called indirect financial management, and under these financing agreements, the mission, represented by the head of mission, of course, will be able then to take the necessary decisions to implement the budget allocated to the mission. As I said, within the EEAS, we have the necessary structures for the planning, the conduct, but then also the supervision and direction of CSDP missions, the so-called CPCC, the civilian planning and conduct capability. This is was also created, in fact, already before the Treaty of Lisbon. One consequence of the Treaty of Lisbon was of course to transfer all the structures that existed in the Council Secretariat over to the External Action Service. But they're not separate. They're not separate entities. They're really full integral part of the External Action Service. Even though we have had court cases where, for example, the CPCC as such or the Civilian Operations Commander were identified as defendants. Which again shows that, of course, to the outside world, the system is not the most transparent one. Talking about the Civilian Operations Commander, this is indeed very much also linked to the question of the so-called chain of command, which is traditionally also, or as per the practice that has been developed, starting with the Council, going via the PSC, then the so-called Civilian Operations Commander, who is based at headquarters in Brussels. That person is at the same time also double-hatted as director of the CPCC, but the Council. It's not a permanent civilian operations commander. It's the Council for each mission appoints each time then the civilian operations commander as civilian operations commander for a specific mission. Of course, the civilian operations commander then benefits from the support of the CPCC in order, in order to give the necessary instructions and guidance to the mission. And then in the field, on the ground, it is, of course, the head of mission that then transposes the instructions he or she receives from the civilian operations commander. So those are the three main institutional actors involved in the running of the missions: Council, Commission, HR, EEAS, and within the EEAS, CPCC and the Civilian Operations Command. Now, turning to the case law. Indeed, as Mark mentioned this morning in his presentation, the basic question arising here, well, why are these cases ending up before the European Court of Justice in the first place? Looking at Article 24 and Article 275 TFEU, which established as a general rule that the Court of Justice has no jurisdiction in CFSP except for Article 40 and sanctions. Well, indeed, the first case, indeed, where this came up, the so-called H case, one of the longest running cases in the history, I think, of the court. At first instance, before the General Court, it started, let's say, as one could expect at the time, namely that this was a case. What was the case about? I mean, that's important to know, of course. It was about the applicant in that case contested a decision. It was taking place within the police mission in Bosnia-Herzegovina, and the applicant contested a decision taken by the head of mission to transfer that person. It was an Italian magistrate from the headquarters to another location within the geographical area covered by the mission's mandate. And so that decision was contested by the applicant, but at first instance the General Court rejected the application, found that indeed this was linked to the operational activities of the mission and therefore could not exercise judicial control. Now in the famous then the applicant appealed, and in the famous then H judgment of the Court of Justice, the court came to a different conclusion. Namely, indeed, it found that at its core, this decision of the head of mission, of course, while taking place in an operational CFSP, CSDP context, could still be qualified as well as an act of staff management, similar to decisions of a new institution transferring one official to another post within the institution, or giving another assignment to that person. Now, I think some commentators found the reasoning behind the judgment perhaps questionable to some extent, but nonetheless, the court now, this is standing case law that indeed similar questions, staff management, are under the jurisdiction of the court, and the court will indeed examine the merits of that case. Subsequently, the case went back to the General Court, and it was the General Court, in fact, interestingly, then rejected the application on the merits because it found that, in fact, the operational aspects were still predominant, and it could not really question the operational decision of the head of mission. It only looked at whether the internal procedures in terms of due process concerning that decision were respected. Then later on, it went back on appeal to the Court of Justice, who in fact, again, came to a different conclusion, finding that indeed there were perhaps also some other aspects that previously were not known. And this decision by the head of mission had perhaps also some other personal components concerning the person concerned, and hence could be questioned in terms of their legality. So that's the H judgment. Well, we have, of course, the so-called the Italiano judgment, where the court already before had decided that when it comes to the application, indeed, of the financial regulation, if a decision taken by a mission that has financial implications is at stake, then likewise, it is not excluded from the court's jurisdiction. In the Italiana case, as you may know, at the time the mission itself did not yet have legal capacity, so was not considered to be able to be a defendant. And in any case, the court came to the conclusion, and it might still come to the same conclusion nowadays, that in fact this action was attributable to the Commission, because the Commission is responsible for the execution of the budget. Perhaps one back briefly to H. What is striking about the H case is less perhaps the finding of the court that it has jurisdiction because it is a staff management case. What I personally found striking is that the court in fact attributed then the responsibility of the attack decision to the council, looking at the chain of command, saying, oh, but the council is at the top of the chain of command, and hence it was eventually the council who was condemned to pay damages to that person. But that is a bit strange in my view, because it is quite clear that the council was never involved in this decision taken by the head of mission on the ground concerning, the management of his staff. But nonetheless, the court came to that conclusion, and that's probably why the council is still cited in many of these cases as defendant, because that question then, to what extent decisions taken at theater level can be imputed or attributed to the institutions involved, is still very much an open one. The Jenkinson case was mentioned. Again, that's also at its core a labor law case. The complainant complains about the fact that his employment contract as an international contracted servant or agent of the ULEX mission was not renewed after having worked for about 10 or 11 successive short-term contracts for the mission. It was a result of a downsizing of a mission, which was decided for political reasons. That case is still pending on appeal. The General Court came to the conclusion, rejected the claim, found that indeed under the applicable national law, which is also a bit of a question mark in these cases, what is the applicable labor law? There, the contracts that these people sign are not very clear on that, but because that person, the applicant, was an Irish national, the court came to the conclusion that Irish law was applicable, and looking at Irish law in connection with Directive 1999, a directive of 1999, that establishes basic principles on the possibility of having successive short-term duration contracts. The court came to the conclusion that because of the specificities of missions, they're in principle their short-term nature, the fact that they're subject to changes, the fact that the budget is renewed every year or every 2 years, the fact that the head of mission changes every 1 or 2 years, the court considered that indeed it was objectively justified to have a succession of short-term contracts. It remains to be seen, indeed, as I said, the case is under appeal, whether the Court of Justice will follow the General Court. Lastly, quite important, another case involving ULEX, again, similar actions that started before the Belgian labor courts, because at the time, the employment contracts of the international staff gave jurisdiction to the Belgian courts. Now we have changed the system. Now the contracts give the jurisdiction to the Court of Justice of the EU. Again, the Belgian labor judge was the action, a collective action, again, about unlawful termination of contracts or unlawful non-renewal of contracts. And the Belgian judge also had difficulties identifying the right employer. And both at this point in time, we're still, as defendants, still the Commission, the Council, the External Action Service, and the mission ULEX Kosovo. The Belgian judge could not address this question, so sent a referral request for a preliminary ruling to the Court of Justice. Significant because it's the first time ever that, in fact, the Court of Justice was asked by a national court to interpret a provision of CFSP law, of a CFSP decision adopted by the Council. And there again also, we raised the question of the jurisdiction because it was not obvious from the H and Il Italiana case law that the Court of Justice would also have jurisdiction for a request for a preliminary ruling in relation to a CFSP Act. But there again, the court applying also the H case law, came to the conclusion that indeed it could exercise jurisdiction. And there, in a nutshell, this judgment is quite interesting, because there the court, without addressing the question of the employer, comes to the conclusion that, interpreting the relevant provisions of the joint action setting up ULEX Kosovo, that in fact ULEX Kosovo should be the sole defendant in this case, because of its legal capacity, including and because indeed finding that this legal capacity also extends to decisions or acts that were taken before 2014, before the mission acquired legal capacity. I think I can stop there. Perhaps just one final word. I mentioned that at the beginning, the question of non-contractual liability. Indeed, there are two cases pending where, again, the applicants are trying to establish that ULEX Kosovo, again, committed human rights violations because they omitted to properly investigate certain war crimes. And there, that also raises the question of the application of Article 340 TFEU to the CFSP context. Thank you very much.
Thank you.